And thanks very much, Karine, and good morning, everybody. And thanks to the Academy of European Law and the Maltese Presidency for organizing this conference today. I've had the pleasure of listening to the different presentations and the discussion, and getting a lot of very interesting observations and feedback on some of the main economic and labor perspectives on the issue of immigration for this particular category of highly skilled third country nationals. My perspective and the perspective of ECRE is more focused on the situation of refugees and asylum seekers. When I say refugees, I cover broadly what we would call in EU terms beneficiaries of international protection. So both protection status is foreseen in EU law. And one of the reasons why this reform is very important for us is evidently the fact that the Commission has taken a very conscious step of linking two regimes, let's say, in EU legislation and policy making that were not very often intertwined, even though in practical and in reality terms, we see obvious overlaps and obvious linkages. So that means that the blue card as a legal migration instrument and as a labor migration instrument makes an advance to look at the situation of refugees in Europe and to break a very traditional perspective we have on refugees as non-economic actors, as people who may or may not be fit to participate in the labor market in highly skilled positions. So that's already a very positive step. But I think by way of preliminary observation, it would be interesting to see how we treat refugees at the moment in terms of rights, in terms of mobility, or of other rights vis-a-vis other third country nationals, and what this proposal could mean given the wide package of rights that it comes with that we've discussed extensively this morning in the first part of the roundtable. So just to state very clearly the picture when it comes to the EU's common European asylum system is one that is often difficult to reconcile with many of the benefits of an integrated approach that tries to connect labor markets as much as possible, as we've heard. So refugees and people that get other forms of protection in the EU have a right to stay in the country that protects them, of course, but that doesn't come with an automatic right to move and settle in other European countries. Practically, the only way for a refugee to move and to settle in another EU member state is if they wait out the requisite period for obtaining long-term resident status, so that is 5 years, and only then, by virtue of the long-term resident status, would they be allowed to settle in another member state. So mobility is not something that we foresee as something relevant to refugee status in the EU. Other rights are also related, and we see also discrepancies in the way that we treat labor migrants and refugees. One crucial example is family reunification. Some categories of people who benefit from international protection, namely those that get subsidiary protection in the EU, are facing much more restrictive conditions when it comes to reuniting or bringing family members to the EU. In some cases, in countries like Malta, actually, Greece, Cyprus, recently Sweden and Germany, they are excluded from this right altogether. So in practical terms, we see already that for crucial rights that are very important and sort of a key part of the decision-making process when deciding where to settle, where to work, such as family, such as mobility, whether you are a refugee or, for instance, a blue card holder, can mean a huge difference for the life of the individual. So in practice, the decision to include beneficiaries of international protection in the scope of the Blue Card Directive is, of course, a very welcome step because it nuances, it qualifies those distinctions to some extent. Not for all refugees, of course, as we would want them, but for those that are deemed to be highly skilled. One question, of course, that arises is whether we are fragmenting the landscape even further, whether we are now creating subcategories of beneficiaries of protection. Those that can move because they are deemed to be highly skilled, and those that cannot and have to stay in a member state that may not be allowed to bring their families over, etc. One other aspect I wanted to discuss, and this stems not from the Commission proposal itself, but from the position that the Parliament has taken, and the vote today, I think, has confirmed that the proposal from the rapporteur, so the initial version of the report, has been kept intact, was to try to broaden this scope of the directive even further, and to look not only at the people who already benefit from international protection in Europe, but also persons who seek it and are allowed under the terms of EU asylum law to have access to the labor market. In very quick terms, currently EU law foresees flexibility for member states to allow labor market access no later than 9 months when a person seeks asylum. So if, depending of course on how it's been transposed and implemented in the member states, asylum seekers may be directly allowed to work in a member state as soon as they submit an application, might have to wait 3 months in some countries, 9 months in others, etc. The idea, according to the Parliament, would be to include those in the scope of the Blue Card Directive and give them the possibility, even before the claim has been fully processed and a decision taken to grant them protection, for them to actually go ahead and apply for a blue card in another country, for instance. One key question that arises here is not only the access to economic and job opportunities, but also the link between the labor migration status and the protection status that a person is seeking. For the Parliament, this means that when an asylum seeker would apply for a blue card, and if they would get it, their asylum procedure would be suspended during the period where they work as blue card holders. So we would kind of put the, let's say, asylum component on hold until the duration of validity of a blue card has expired, and then we would go back to the asylum procedure. In practical terms, this might raise a few questions, namely when it comes to quick access to protection, which is an international law imperative and also a high priority for the European Union's instruments on international protection, making sure that people who need protection can access it as quickly as possible and not be left in a state of legal limbo. And this brings me to a second and slightly more technical point, but one that could be very interesting when it comes to how we treat refugees as blue card holders vis-a-vis mobility between different countries. So we heard from Anna this morning a very interesting observation on the member states' perspective, where one of the key difficulties is so-called dual migration status, right? The idea being that for legal purposes, you can either be a protection beneficiary or a blue card holder, and it might be very difficult to reconcile the two. From a policy and principle perspective, this is already a bit difficult to reconcile with the overall idea behind the proposal, namely that somebody can be both a refugee and a highly skilled worker, and you can actually allow them to use those skills without denying them the fact that protection needs are still there, and the rights attached to refugee status need to be guaranteed at all times. And these obviously place the individual in a very different situation than any other blue card holder. They have very specific needs that need to be addressed and need to be guaranteed. So you could have scenario in practice where, let's say we have a person who obtains protection status in one country, they apply and they successfully become blue card holders, and they follow the scheme of the Blue Card Directive in order to engage in mobility for work purposes. One of the difficulties that might arise relates to whether their rights, by virtue of their refugee status, can actually follow them in that other country. This is something that is not fully taken into account by the Commission proposal at the moment. So we assume that the person would move to another country under intra-EU mobility as a blue card holder and as a worker, not as a refugee. Because, as I mentioned earlier, we don't see refugees as a category that can move between member states by virtue of refugee status. But then you can have very delicate questions with regard to asylum and to protection needs that could arise when the person is in the member state that is not the member state that has protected them. And there we get into a bit of a fuzzy area also in international law, which we would call transfer of protection responsibility. So if one country recognizes a person as a refugee and the person moves to another country for any purposes, does the other country have the responsibility to grant all the rights that are attached to protection? This is something that, of course, falls outside EU law, and this is also acknowledged in in the directive proposal. It's not something that the directive seeks to regulate directly. And it's also an area where you have international instrument, for instance, from the Council of Europe. You also have some bilateral arrangement between countries, namely in the Benelux area and in Germany, for instance. But the picture is very fragmented, and it's not clear how you exactly resolve those questions of who is responsible for protection when the person that has refugee status has moved somewhere else. The proposal makes some degree of acknowledgement that the second member state has a role in defining and in determining the person's protection needs, because it allows the second member state to expel the person from its territory in some specific circumstances. So if the second member state wishes to remove the person from the territory and the person is a beneficiary for international protection, in principle they need to check with the member state that granted protection whether that protection still exists. And if so, obviously a different path must be followed. But there is a provision in Article 22, paragraph 6 of the proposal that allows the second member state to forego that process of checking the protection needs if they feel that the person falls into what the Asylum acquis calls revocation clauses. So for instance, if the person is deemed by that second member state to be a threat to national security, that member state could, according to the proposal, directly decide to remove the person and return them, let's say, to the country of origin. What we see as a big question and a bit of a gap is the splitting, let's say, of that part of decision making from the rest of the asylum process itself. It's very difficult, in our view, to actually decide whether a person can be removed back to their home country without having full access to their file, to their asylum procedure, because obviously we're talking about a country other than the country that processed the asylum claim. So again, with this proposal, the EU goes some way into acknowledging that member states can look at some elements, namely when it comes to removing a person from their territory, but not look at the positive elements that come with refugee status, namely granting them the necessary rights to be able to rebuild their life and integrate. I had one very final point that builds a bit on some of the points that Yo made in terms of documentation requirements. One of the issues that is somewhat peculiar to the predicament of refugees has to do with availability of documentation. Obviously, given the circumstances of flight from home countries, the very limited and very often inexistent possibility to contact authorities, to contact institutions in the home country, means that very often people come without documents or without some of the requisite documents that might fall into within the scope of the Blue Card Directive. And there we have, I think, good sources of inspiration from other EU instruments, namely the Family Reunification Directive, that acknowledge that difficulty that refugees go through, and that make sure that member states apply the necessary flexibility when dealing with refugees to leave them some possibilities to prove skills, for instance, without necessarily having rigid requirements that would be applicable for other categories of third country nationals. This is also done by some countries when it comes to issues of national prerogatives, like citizenship. Very often, the documents required for access to citizenship and naturalization are relaxed when it comes to refugees because countries acknowledge that there is an intrinsic difficulty in finding those documents. I'll leave it at that, but I'm looking forward to the Q&A and the discussion. Thank you.